Merci. Merci beaucoup, and thank you for being here so early on this lovely Calgary morning. This is going to be a great conference. It's tackling a very important theme. Ça aborde des questions de plus profondes qui touchent la profession de très près. Les questions d'accès aux justices, la question de comment trouver des moyens pour rendre la profession de pratique de droit relevant dans le 21e siècle. Merci d'avoir choisi ce thème tellement important et merci de m'avoir invité de participer dans votre programme ce matin. I want to begin with a story. One of the oldest stories in human history. It is the story of Ulysses, king and adventurer who lived over 3,000 years ago, as taken up by the poet Alfred Lord Tennyson in his great poem, Ulysses. Ulysses had traveled the world. He had fought great battles. He had won, after many arduous years, the city of Troy. Home at last, he sits by the hearth. Yet he is not content. His mind goes to new ventures. He concludes that, and I quote from the poet, "Some work of noble note may yet be done." And so he resolves to move on. He says, and again I quote, "Come, my friends, 'tis not too late to seek a newer world." Today, as my thoughts turn to the future of the legal profession, I take Ulysses' words as my theme. Like Ulysses, the legal profession has a noble history, replete with great achievements. But as in Ulysses' world, times are changing and noble work remains to be done. The legal profession, as did Ulysses, has a choice. It can sit back and rest on what has been accomplished, or it can resolve, as did Ulysses, to venture forth to seek a newer world. I believe that a strong, independent legal profession, une profession qui est relevante et indépendante, is essential to the rule of law and to democracy. It is vital to provide justice to individuals who need it. It is vital to buttress the economy and provide a safe place where people can invest and enjoy economic growth. And it is vital to ensure that state power is exercised constitutionally. In a word, a strong independent profession is vital to maintaining the rule of law, essentiel à la continuance de règles de droit. To ensure that it remains strong, independent, and relevant in the 21st century, the profession must rise to the challenge of meeting the needs of our times. It must, like Ulysses, move forward with conviction, hope, and optimism. To do this, I suggest, the profession must ask itself 3 questions. The first question is, where, looking at matters honestly and from a collective perspective, do we stand as a profession in the quarter of the 21st century as we enter such. Second, having assessed where we stand, have a look. What forces have brought us to this position? What is behind the challenges we face? And third, against this background, how can the profession move toward the newer world it must seek? The first question is, where does the profession stand? 4 years ago, The Economist ran an article entitled, "Law Firms, a Less Gilded Future." The piece painted a bleak picture of the legal profession. It mentioned that, according to an annual survey by the National Law Journal, the 250 biggest U.S. law firms in 2009 shed more than 9,500 lawyers. In recounting the collapse of the big American IP firm Howry in the midst of the 2009 recession, the article proposed that a downward trend was beginning to hit the profession and was likely to stay there. Increased competition for market share, plummeting profits, clients' determination to keep bills down. These were symptoms, the Economist opined, of a graver malady. This pessimistic view has been echoed by legal commentators, scholars, and lawyers. One has only to go to the shelf of the local bookstore, where the titles of the books on the legal profession and its problems speak volumes. I'll give you a few. The Lawyer Bubble, Declining Prospects, The American Legal Profession in Crisis, Failing Law Schools, The End of Lawyers, The Vanishing American Lawyer, The Destruction of Young Lawyers, The Betrayed Profession, The Lost Lawyer. These are mainly American books, but they find their parallels in England and in Canada. This is no isolated phenomenon. The assault or the critiques that we're hearing of the legal profession and its way of doing business have two facets. The first is internal, and the second, external. Premièrement, permettez-moi de m'adresser au concern interne. Let me turn first to some of the internal concerns. Discontent within the legal profession runs deep. A fair share, perhaps unfairly, of the blame is laid at the feet of big law firms. As one Canadian commentator says, and I quote, "Most law firms around the world still practice law the way it has been practiced for centuries, a labor-intensive endeavor carried out by high-priced personnel billing by the hour. Protected by legislated monopolies, law firms have been allowed to grow complacent, fat, and inefficient." End of quote. And while we read in The Economist of some law firms shedding many lawyers, it seems that law firms are often only getting bigger. In 1960, the largest American law firm had 169 lawyers. Today, it has over 4,000. Discontent within the legal profession often focuses on the culture of law firms, a culture where long hours and exponentially escalating billable hours are equated or taken as the talisman of value to clients of the work done and commitment to the firm. This culture imposes a high professional price on lawyers with family responsibilities, often women. The stats of how women face greater struggles in the legal profession are striking. I quote from a recent study. "Women constitute more than a third of the profession, but only about a fifth of law firm partners, general counsels of Fortune 500 corporations, and law school deans. Women are less likely to make partner, even controlling for other factors, including law school grades and time spent out of the workforce or on part-time schedules. Studies find that men are 2 to 5 times more likely than women to make partner. Even women who never take time out of the labor force and who work long hours, the study says, have a lower chance of partnership than similarly situated men. Is this inevitable, or is it part of a culture? This culture also takes its toll, as we've just heard your president say, on mental health. Lawyers suffer from disproportionately high rate of depression, alcoholism, and substance abuse. Recent surveys report that 6 out of 10 lawyers who have been practicing law for 10 years or more would advise young men and women to avoid law school. That was in the United States, but some might say the same prevails here. One study found that almost half associates leave firms within 3 years and 3/4 within 5. Finalement, de plus en plus des membres de la profession cherchent des moyens d'intégrer des nouveaux et nouvelles avocates dans la profession et la pratique du droit. A final criticism, or more accurately, a paradox from within the profession, is that while on the one hand, many of society's legal needs are going unmet, a significant number of law grads seem to be struggling to find articles and to enter the profession. What's wrong with the model? Why the disconnect? Lawyers and law societies are asking themselves. And what can be done to remedy it? Let me turn then to some of the external concerns. And I want to assure you I'm going to be pessimistic only a little bit longer. I will get to the happy part of this speech. Some concerns within the legal profession, from concerns within the legal profession, let me look at the concerns outside. Sometimes the criticism from outside is gentle. The mild contempt of the jokes about lawyers that turn on motifs of self-importance and greed. I'm not a fan of lawyer jokes, but one of them is pertinent to my subject today, and you no doubt know it. It goes like this. How many lawyers does it take to change a light bulb? The answer? What's change? I like the variation of the joke that's been developed for psychiatrists. How many psychiatrists does it take to change a light bulb? Anybody know? Well, the answer is 1, but the light bulb has to want to change. D'autres critiques sont plus sévères. Other criticisms are more substantive. The main one that we're hearing from the outside is that justice is no longer accessible, and you've already heard a lot about access to justice, and goodness knows I have said my share about access to justice in the past. But you know the mantra now by heart. Lawyers are too expensive, court proceedings are too complicated, and they take too long. If you go to court, you're crazy, or it's at very best, it's got to be a last resort. People say, take me anywhere but the justice system. Now that's an exaggeration, but that's the kind of criticisms one sometimes hears. And statistics do support the view that accessing the justice system with the help of a legal professional, and this is important, to access, you don't just need courthouses, you don't just need judges sitting there, you need a legal professional in most cases to guide you through the processes, to be your mouthpiece, to speak for you. Statistics show this is increasingly unaffordable to people. Nearly 12 million Canadians will experience one legal problem in a given 3-year period, we're told, yet few will have the resources to solve them. There's an American study that says 70 to 90% of legal needs in society go unmet. And all this has serious consequences. We know that unresolved legal problems adversely affect people's lives and ultimately the public purse. Problems develop that should have been cut off, should have been answered and resolved at an early stage. Among the hardest hit, of course, is the middle class, people who earn too much to qualify for legal aid, but not enough to sustain proceedings of any complexity or length. So the cry for access to justice is rising from what was once a dull murmur to a crescendo. Other actors, governments, courts, bear much of the responsibility. But never forget that lawyers are critical to the solution. Lawyers hold the keys to the exclusive domain we call justice. But too often, critics say, they use those keys to open the doors only to a privileged few. Il n'est pas seulement au Canada où on trouve ces problèmes. The sad truth is that around the world, the legal profession and the courts are too often not fulfilling the expectations of those who need legal services. Legal systems everywhere are experiencing an access to justice crisis and are responding in different ways. In England, for example, the response has been a draconian shrinking of services available, a discouragement of people accessing justice. In Canada, our response has been otherwise. Through the Cromwell Commission and others, we are seeking to make those services which we believe to be the right of every citizen available. And the bar has playing an enormous role in this. I believe we have to do that. This is vital to, obviously, providing the justice that people need. Statistics show that people who don't get lawyers to help them with their legal problems get bad results. And so, as servants of justice, lawyers have a duty to help solve the access to crisis that plagues our to justice that plagues our legal system. It's also vital to the rule of law. And finally, I think it's vital to the future of the profession. If the legal profession fails to meet the demands of the public for prompt and affordable justice, people in search of justice will go elsewhere, rendering the profession increasingly irrelevant. The picture I've painted, a picture of internal discontent and external critiques, seems bleak at first blush. However, increasingly members of the legal profession and those who study it are casting an eye to the future and seeing not bleakness but promise. They are examining the forces of change at play and asking themselves, how can we respond? These visionaries have much to teach the entrepreneurial lawyer of today. Like Ulysses, they have concluded that there is important work to be done and that it is not too late to seek a newer world. This brings me to the second part of my remarks, which is the forces that have caused the changes and presented the challenges of which I have just been speaking. Underlying the changes the profession is grappling with is the most profound driver of change of our times, la révolution digitale, the digital revolution. The digital revolution has, in a few short decades, changed how the world computes, communicates, does business, and yes, how it thinks. Consider this. 2 years ago, Google's Eric Schmidt was saying every 2 days his company created as much information as all of humanity did from the dawn of civilization until 2003. A veritable industry is emerging to help cope with the unfathomable size of the data sets spawned by the pervasive and worldwide use of information technology and the internet. According to Ray Kurzweil, by 2020, the average desktop computer will have the same processing power as the human brain, and by 2050, it will have more processing power than all of humanity combined. Or consider how networks like Facebook and LinkedIn influence how we forge and maintain personal and professional relationships. Think of how smartphones or apps like Twitter mean we're constantly connected to each other. Think of how the internet is changing how we think about the world, including lawyers and judges. As the Canadian artist, novelist, and cultural commentator Douglas Copeland would no doubt observe, the number of people who can still access their pre-internet brain is ever decreasing. Indeed, among the ones I know, I think first and foremost, I will have to put my husband, who has had a healthy disdain for anything with pictures, electronic pictures on it. But most of us are not so fortunate. We are facing a different way of thinking, a different way of communicating, sometimes a harsher way, sometimes a way that itself creates problems. The legal profession is not immune from the effects of the digital revolution, and we're part of it, and there's no escape. And this is good. Lawyers benefit enormously from this, from processing information and producing work more efficiently than lawyers in the pre-digital era could ever have imagined. And when I started practicing law, and I hate to say this because it makes you know, if you don't already what you do, how old I am, we used to use whiteout to change documents. We used to cut and paste when I first became a judge to put our judgments together. And I don't mean on a computer. I mean with Scotch tape and scissors. Well, you know better than I. Things are changing. We have huge resources. We used to go to the library and pick out a book. Now we have huge resources, databases of legal precedent. We access everything we need online. We file court records online. Social networks and marketplaces are making it easier to share skills, build, and sometimes lose reputations, to identify potential clients. And within our law firms, we're sharing through IT, and we're avoiding duplicative work, and we're building institutional memory, and we're sorting out conflicts in ways that are much more efficient than before. Douglas O. Linder and Nancy Levitt, who've studied the situation, are optimistic. They say, and I quote, "For a new generation of nimble, tech-savvy lawyers, the brave new world can be an exciting new place." So the digital revolution has transformed the way the lawyers work, and for the better. Yet as it does so, it is undermining the fundamentals of legal practice. Let me mention 3 related challenges the digital revolution presents for the legal profession. The first challenge is that the digital revolution makes available new ways of obtaining services that in the past only lawyers could deliver. Des moyens nouveaux de fournir des services légaux. And we've already heard a little bit about this today. Today's lawyers find themselves competing with legal software and services provided over the internet. LegalZoom, a US-based company, makes legal documents available to people and businesses who cannot afford routine solicitor work involving incorporations, trademarks, wills, and estates. Today, the typical North American smartphone has easier access to legal sources than most lawyers did in the 80s. Consider finally that it's already possible in some jurisdictions to obtain online cheap or free legal advice and to engage in online dispute resolution, all electronically without engaging human beings. In the UK, over-the-counter divorce will simply be available. Maybe that's as it should be, but it certainly is a change. Type in your info, a little check done by the computer, and out comes your decree. The face-to-face consultation and advice that is the hallmark and that some of us believe is so important to the lawyer's work is increasingly being replaced by new technological-driven alternatives. People will get solutions to their disputes and to their difficulties, but we must ask ourselves, Will they get justice? Le deuxième défi qui découle de la révolution digitale se trouve dans les demandes changeantes du public, des demandes pour un meilleur système de justice. The digital revolution is producing a public that demands the delivery of legal services with greater speed and efficiency and at less cost than ever before. The digital world is a fast world. Consumers of legal services, be they corporations or individuals, are not prepared to wait for results. The time-honored legal phrase, with due deliberation, has no place in the new digital world. And that's not all. The digital world is a competitive world. Consumers of legal services are no longer prepared to pay blindly for justice, whatever the cost. Be those consumers governments funding legal aid for criminal and family cases, or individuals and corporations seeking legal advice for the resolution of disputes. A third challenge flowing from the digital revolution is to the very assumptions that underlie the legal profession as we know it. And the most basic of those assumptions is the assumption that the legal profession and the legal profession only can deliver legal services. Cette idée de monopole se trouve de plus en plus vulnerable. There are good reasons for that rule. The reasons are that the public should not be vulnerable to advice and assistance from people who are untrained, who are not subject to the disciplines and constraints that law societies impose. Yet more and more those reasons are being set aside as people find solutions to their legal problems elsewhere. We all know that historically, only qualified lawyers, practitioners vetted and certified by bar associations, were permitted to provide legal services. And then they could only do it in certain forms, such as partnerships. But those assumptions are increasingly challenged. In the age of the internet, people are questioning why they should be forced to go to expensive lawyers if they can get an answer more easily offline or from some electronically available corporation. Why should they retain lawyers when integrated professional firms might better meet their needs at a lower cost? Why don't we resolve simple disputes in simple and effective and inexpensive ways, leaving the full court process, the full Monty, to complex issues that require it? These are the questions that are being asked. The old assumptions are being questioned. And in the face of that, we are finding that the profession, and the Canadian legal profession is no exception, is asking how it can change its ways of operating, its rules, to, on the one hand, maintain the standards that are required for people obtaining legal services, needing legal services, and on the other, provide those services in an effective and affordable way. And we're seeing lots of responses. We're seeing, for example, in 2004, the Attorney General of Ontario asking the Law Society to expand its public interest jurisdiction and provide independent oversight over paralegals, licensed quote-unquote professionals who, without all the training that a lawyer provides, must meet certain standards of competence and training, and who may fill the needs of people who find lawyers too expensive but are unable to navigate the legal system, unable to deal with matters such as small claims court or working their way through administrative tribunals. And everywhere we're seeing rules being liberalized. In the UK, this is happening. In the United States, in state after state, it is happening. Recognizing this, The Canadian Bar Association recently launched its Legal Futures Probe into the future of the legal profession to help the Canadian legal profession remain vibrant, viable, and confident in the face of change. I congratulate you on that very necessary step. Everywhere, more and more, the profession is accepting that old monopolies are fading, and it has to provide new ways of doing business and new ways of ensuring that the public gets good justice. Increasingly, calls are heard for law schools to adapt their curricula to these new realities. The question is not whether the rules governing the legal profession should be liberalized, but how. To sum up, the digital revolution and the modern social and economic forces it has unleashed are creating new modes of delivery of traditional legal services, creating new demands and expectations for meaningful access to justice, and eroding some of the fundamental assumptions upon which the legal profession as we know it has been built. This is compelling the legal world to revise old patterns and approaches, to seek, in Tennyson's phrase, a newer world. This brings me to the final portion of my talk. Où maintenant? Where do we go from here? What is the way forward? I've been talking about the state of the profession and its critics, both internal and external. And I've talked a little about what is driving these critiques. The new ways of business and higher expectations of the public tied to the digital revolution that have resulted in challenges to how lawyers do business and demands for new models and revisions to court rules and professional rules. Permit me now to venture a few thoughts about the future. Some say the legal profession, historically conservative, cannot alter its ways. Going back to the joke, what's change? Others, echoing Ulysses' debate with himself, muse on whether it is too late to change. I think the truth lies in the psychiatrist joke I told you earlier. We have to want to change. But change itself is not the aim. Some changes can be negative, some changes can be good. What I'm saying is that we have to open our mind to changing when change is necessary, when changes will bring salutary benefits. We must not close our mind to the changes that are increasingly being forced upon us. Indeed, the reality is that change is already upon it. We can't avoid it. If we believe, as I do, that an independent and vibrant legal profession is essential to public welfare and the rule of law, if we want the profession to remain relevant into the next century, I believe our only choice is to turn the changes that are already upon us into opportunities to build a new and invigorated legal profession. The first step, as I say, is to accept the idea of change. Accepter que les changements pour remédier à des défis auxquels la profession fait face actuellement. Lawyers and judges need to stop fearing change. Certainly, not all changes are good, but many are good and many are necessary. We have to accept a mentality where we say, yes, change is not an evil, but rather a source of new opportunities. Richard Susskind, writing in the context of changes in the United Kingdom, predicts that over the next few decades, the ways in which lawyers work will change radically. As he puts it, entirely new ways of delivering legal services will emerge. New providers will enter the market, and the workings of our courts will be transformed. Unless they adapt, many traditional legal businesses will fail. On the other hand, he says, a whole set of fresh opportunities will present themselves to entrepreneurial and creative young lawyers. One source of opportunity for the profession lies in making innovative use of technology and service delivery models without sacrificing quality. Ça va sans dire, it goes without saying that lawyers of the future will have to be efficient if they're going to remain competitive in the fast-paced world. They'll need to develop strategies to cope with the fact that in the very near future, straightforward out-of-court work will face brutal competition. They'll need to use technology in creative ways, and they will have to accept that some tasks traditionally performed by lawyers can be outsourced to non-lawyers. Richard Susskind argues that the traditional artesian model of lawyering is already being replaced by commoditized legal work, and that the broader economy's relentless pressure toward more for less will intensify this trend. In other words, instead of artisan justice, individual justice, one-on-one justice, we will move to commoditized justice. In like manner, Benjamin H. Barton says, and I quote, "Computers, non-lawyers, outsourcing will continue to try to peel off simpler legal tasks and more basic legal questions and commoditize them. Legal services will no longer be that very professional, special thing given by the legal profession as part of the solicitor-client relationship. Unless lawyers rise to meet the challenge, it will increasingly be something you buy off the internet." Susskind says this will require us to do some picking and choosing as a profession. We have to, he says, identify work that can be routinized, and undertaken more efficiently, whether by less qualified, lower-cost human beings or through computerization. The worry is, of course, that the more people buy law and justice as a commodity, the less sure they can be that their particular needs, their particular situation, are really being addressed. So one model suggests that lawyers need to bring these commoditized services, be they by computer or by less highly trained individuals, within the overall umbrella of the legal profession. The task of the legal profession is to see how we can do the work better and more efficiently while maintaining the high professional standards to which we have always been committed. The integrity of legal processes and the interests of clients, I believe, must never be sacrificed to efficiency. We have to maintain these. Maintaining these is the essence of what it is to be a lawyer in the service of the public. Flexibility and innovation, yes. Abandonment of core professional values, never. Therein lies the challenge and the opportunity. A second source of opportunity for the profession lies in expanding services to sectors that are underrepresented, who have not received legal services in the past, whose legal needs are not being met. Many communities have traditionally been underserved in terms of legal services, in terms of legal services. Some suggest that the way to deal with this is just to deal with all the problems we're facing is to cut back on legal services, less legal aid, less pro bono, less access. But there's another approach. The other approach is to say, what are the legal needs out there that are being unmet? And how can we devise ways for lawyers to meet those needs? Ways that will help lawyers practice their profession and earn a living and will benefit those individuals whose needs are being unmet. And we need to look to new and imaginative solutions, and people are doing this. Legal insurance schemes tied to home insurance policies or employment. New ways to deliver basic needs like wills and probate. Encouraging communities who may mistrust the law to avail themselves of it. When you think about it, there are many, many new Canadians who come to Canada from parts of the world where justice systems are dishonest or dysfunctional. Those people come to Canada with legal needs, but they don't trust the justice system in many cases. So their legal needs go unmet. The profession can address that by encouraging these communities 2, trust our law, telling them about our legal system, ridding them of their fears. And for a final example, providing services to the increasing number of people in what we call the older demographic. Old needs, new ways of servicing them. Lawyers should not forget that those whose legal needs are not being met come in many forms. They can be individuals who are trying to buy a house or pursue a personal injury claim. They can be business managers seeking to navigate complex regulatory regimes. They can be in-house counsel who require external legal advice to conclude deals. They can come from old persons' homes, from new immigrant groups. What they have in common is that they cannot afford legal services when delivered in the traditional way, and they cannot afford the disproportionate cost in many cases of going to court. It's the legal profession's challenge to find ways to meet these needs. A third opportunity for the profession lies in restructuring the ways law firms have traditionally organized their internal operations. And I'll just speak of two briefly. The first is how we use our physical space, how we get together, how we do our business, and the second is changes in billing practices. First of all, the traditional legal office. Electronic communication with clients and colleagues frees lawyers from the need to huddle together in the same physical space. And it permits more flexible places and raises the possibility, indeed, in some cases, of the virtual office. Arrangements such as these may increase efficiency, allow lawyers to reach clients they might not otherwise reach, and provide flexibility to people who, for family or other reasons, find it difficult to check into a distant office each morning and stay there the entire day. Once more, the key lies in finding the right balance. In this case, the balance between the value of personal interaction between lawyers in a firm and flexibility in working arrangements. Or consider the traditional ways lawyers have organized their billing and evaluation of service to client and particular lawyers' net worth. I'm old enough to recall a time when law firms billed on the basis of value to the client rather than billable hours. The billable hours model was introduced to Canada in the 70s, and it transformed the way lawyers billed. And it's expanded over the years that have intervened. 30 years ago, most partners billed between 1,200 and 1,400 hours a year. Most associates between 1,400 and 1,600 hours. Now I'm told the figures are much higher. One author writes this, and I quote, "Many firms today would consider these ranges acceptable only for lawyers who had died partway through the year." End of quote. Today, on average, lawyers are expected to bill, and you may correct me on this because I'm not as close to the profession anymore as I should be, but I'm told around 2,000 hours a year, which I'm told requires 50 to 60-hour work weeks. Valuing work only on the basis of time spent, the number of hours you've put in, shifts the focus to some extent from quality and the result achieved to simply how many hours you put in. In a way, that word commoditize fits here. It commoditizes legal services. Both are relevant. How the quality of your work on the one hand is relevant, and the time you put in, it seems to me, to fair fees and to fair evaluation of a particular lawyer's contribution to the firm. And law firms are starting to recognize this. We're seeing proposals for methods of charging that are not exclusively time-based. We're seeing law firms undertake work on fixed cost basis or an upper limit cap basis. And we're seeing law firms adopting value billing, charging for the value of the work undertaken rather than the time expended. The key word here, I think, is flexibility. More flexible approaches to billing are coming, and we should not view them with anathema, but as opportunities. A fourth source of opportunity lies in collaboration with other lawyers and professionals. Clients' problems are increasingly complex, polyvalent, and incapable of solution on uniform cookie-cutter models. And we now have the technology and the wherewithal to collaborate with other professionals, other lawyers, other people who can help our clients solve their problems in the way they should be solved. Lawyers often are now contracting out to law firms for specialized legal help on a case-by-case basis. They're using social media to multiply collaboration opportunities, and clients are sometimes coming together to share the cost of basic routine searches or services. I've mentioned only a few of the opportunities being discussed and implemented in face of the challenges lawyers are facing in the 21st century. But I do believe that they are enough to show that indeed there are huge opportunities out there for new lawyers, for young lawyers, for lawyers who are ready and open to new ideas and serving new sectors of the public. There will be lots of other ideas that you will read about and hear about. And those I have mentioned may flourish or wither. There aren't any quick or guaranteed fixes to the challenge of providing effective and affordable justice and sustaining an independent and vibrant bar in the decades to come. We don't know precisely what the legal profession of the future will look like. We do know, however, that it will be different in important ways from the legal profession of today. Et ça m'amène à la formation des avocats. The way we educate and train lawyers will also have to be looked at. It will be crucial to attract, train, and fit the lawyers of the next generation to meet the challenges of which I have just been speaking. We lawyers have much to offer. We have skills and experience no one else, no other profession can deliver. We have the analytical skills that we learn in law school. No one else can take a problem, a complex real-life problem, dissect it, pull it apart, reformulate it, figure out what to do in the same way legally trained people. And we have experience and ways of developing experience that will help people use these analytical skills, propose sound solutions, and express them in a persuasive way. The task of legal education is to ensure that these skills, the lawyer as problem solver, the lawyer as mouthpiece, the lawyer as the person who can take a mass of complexity and articulate it in a simple, effective way. Our task is to ensure our education systems, be they pre-law, be they continuing legal education, cultivate those special gifts, skills that lawyers bring to society. Creativity, empathy, adaptability, resilience, and breadth of perspective are also essential to today's lawyers. And I'm happy to say what you already know, that the CBA Futures Initiative has also looked at this, and they've talked about an early emphasis on practical experience through supervised apprenticeships, mid-law school, for example. They've talked about broadened and multidisciplinary curricula, and they've talked about education that exploits technology to its fullest. Let me conclude. Susskind predicts that legal institutions and the legal profession, and I quote, are poised to change more radically over the next 2 decades than they have over the last 2 centuries. The question is not whether change will come, but what form it will take. Will the legal profession become increasingly irrelevant as governments, corporations, and ordinary men and women sidestep or find themselves excluded from traditional legal processes? Or will the legal profession rise to the challenges of our times and find new ways to ensure that justice remains available to everyone? Will the legal profession conclude that the world it has made, it suffices? Or will it say with Ulysses, "Come, my friends, 'tis not too late to make a newer world"? Le choix est à nous, the choice is ours. Thank you.